With a second house. Third house in. Nine hundred, but really 918 series. So we're good to go? Okay, oh, I'm sorry. Okay, we need to have call the BZA meeting for Wednesday, September 24th to order. Would you please call the roll?
Mr. Brady,
Here.
Ms. Trumansky. Here. Mr. Brindle,
Present.
Mr. Keithner.
Here.
That's four constitutes four.
Consideration of the minutes from the March 4th meeting. Do I have any comments or corrections on that? If not, I'll entertain a motion to approve.
I'll second.
Let me go first.
Okay, I'm first.
I'll second. Okay, all in favor? Aye. Opposed? Motion passes. And I don't think we have any old business that I know of. New business? Nope. And so this is our annual training. So with that, we'll pass it over to our trainers.
Yeah. So Jules's gonna take us through the BZA.
All right, so. With the BZA, and this is one of the things that we've done, because we've had a training for different boards so far. It's always a question of what to cover, because you have statutes that cover everything and stuff, but I thought it was important for the BZA that we get into some of the case law as well, because you are a hearing authority. So I talk about the title, you've already mentioned the 900, but really the 918 series. Under the Indiana Code, 3674-900 is the BZA series, so they call that the 900 series, which applies to the BZA. The stuff we're going to handle today is what I call the 918. So it used to be that 918, so 3674-918 was a single statute. They put everything into this one statute. And then several years ago, they broke that up. So in the 918, you have the powers of the BZA. First thing is you review orders, requirements, decisions, and determinations. Special exceptions and certain uses in 918.2. 918.3 does not apply, but as variances from use districts and classifications, that is for the area plan commission, so not what you're using. Then we get into the big ones, 918.4, which is a variance of use, and then 918.5, which is a variance of development standards or development variance. So we're really going to talk about 918.1, 918.2, 918.4, and 918.5. That's why I said it's really the 918 series today. As we look at this, let's start with 918.1. You as a Board of Zoning Appeals have the authority and hear and make determinations for
I promise it works. Keep it escape.
escape.
Okay. Oh, okay, never mind.
I'm gonna do space bar because that one brought it up. Any order, requirement, decision, or determination made by an administrative official, hearing officer, or staff member under the zoning ordinance. So when you look at your UDO, it is a determination, final determination made by an official, a hearing officer, or staff member. An order, requirement, decision, determination made by its administrative board or other body. Here's where exceptions come into play, except the plan commission in relation to the enforcement of a zoning ordinance. And then any order, requirement, decision, or determination made by administrator, except the plan commission in relation to the enforcement of an ordinance adopted under the chapter requiring procurement of improvement location occupancy permits. There's like building permits and things of that nature. So Essentially, you are the hearing authority for anything that touches you, Cumberland's UDO, unless that is something that has been being performed by the plan commission. Okay, everything else comes to you. So when we look at this, it's who is going to be dealing with this. So individuals adversely affected by a building commissioner's decision regarding permits. So I want to get a building permit over here. I don't need to go to plan commission for this. I just need to pull the permit from the building commissioner. I go for that building commissioner. He says, no, I want all of this other stuff. Well, that person gets to appeal to you for, on that decision, to see if he actually has to get to all of that stuff. That's Laws versus Lee. Now, here's a bigger one, the Cardinal Industries versus Schwartz. A final business plan site appealing the decision of the acting director of the planning commission. So we're talking about an individual, and that individual had a decision. The court said, you know what? This is a situation in which the acting director of the planning commission could be viewed to be making a decision on behalf of the plan commission, and therefore the exception under the statute applies. And so you cannot bring that in front of the BZA. So if the planning director makes a determination, there's case law out there that the argument can be made that I would not be able to bring that to the BZA for appeal, because that would be a plan commission decision. I can tell you, I don't necessarily agree with that interpretation, but that is what is out there right now. And it's one of the fun things we get to deal with.
So they're talking about Christine, or are they talking about me? 'Cause-
That'd be me.
okay,
If they want to appeal the planning commission, that actually goes.
Yes. So 918.2. Special exceptions and certain uses, approval and denial. So what this statute says is that you, as the Board of Zoning Appeals, shall approve and deny all special exceptions. All special uses, all contingent uses, and conditional uses. So now I've got too many buttons in there. From the terms of the zoning ordinance, but only in the classes, cases of particular. Now, 3 of those you guys really don't. You don't deal with special uses, contingent uses, or conditional uses. Really, what you in Cumberland look at are the special exceptions. So I want to spend some time on specifically a special exception. Maybe. So when we look at the special exception section under 918.2. Cases that define a special exception involves a use which is permitted within a given zoning classification and once certain statutory criteria have been satisfied. A variance from a zoning is a deviation from legislative zoning classification, whereas special exception to a zoning ordinance is a use permitted under zoning ordinance upon showing of certain statutory criteria. And then granting of a special exception is mandatory upon compliance with the status set forth. So what does all of this mean? This means within your UDO, in a given zoning classification, you have probably a chart that lists out, here are the uses that are allowed. Here are the special exceptions that are allowed in this area if these criteria are met. Upon the application for a special exception, as long as those criteria are met, you have no choice but to grant the special exception. Okay, it's a must, it is a shall. You can't take into consideration, but that neighbor doesn't really like it. It's, do they meet that criteria? If you go outside of that, so if they meet with all the criteria and you still deny it, then we open ourselves to challenge under this Ash versus Rush County case, which is pretty old. I mean, there's an 84 case, it's still good on the books, and so we call that really good law because nobody's overturned it yet.
So all we have, I mean, we list special exceptions.
Mhm.
So, what's the criteria of this special exception, I guess?
So in the zoning ordinance, there's a section on special exceptions
Right.
and it lists those. So my staff report, when you get one of those and your motion sheet has each of those items listed. And some uses may have some additional items, like sometimes drive-throughs in certain areas might have some additional standards that they have to comply with in that, but typically it has to do with traffic, impacts on the neighbors. If it's like a home occupation, making sure that there's adequate public facilities, meaning like
Yeah,
utilities,
because
things
I'm
like
thinking
that.
about special exceptions, a lot of them were related to something you normally wouldn't think of L being allowed, and then we have a special exception.
Not necessarily, so special exceptions usually are things that should be allowed, but maybe need just a little bit of extra review to make sure they meet these certain criteria.
Okay.
So normally they are contemplated by your UDO,
Yeah.
saying, in this type of zoning, these are the special exceptions that are allowed. These special exceptions are allowed when this, and this are met. So if we're talking about a drive, it's a commercial area, fast food restaurant, well, that all works great, but if you have a drive-through, you're going to have to go through and prove up the space that you have for the turnaround and how it's gonna impact the number of cars, traffic study, stuff like that, and still the parking. So it should be in your zoning ordinance, and Matt and Christine will pull out, here are the criteria for the special exception. And then once they meet those criteria. Yes or no? Okay. Those are the easy ones, the special exceptions.
Yes.
Now we get into 918.4 and 918.5. We can spend an entire course for a week at AIM talking about 918.4 and 918.5. So what I've done is I've pulled out what I believe to be some of the important things that you guys are gonna have to be dealing with. So when you look at 918.4 as the BZA variance of use, you shall approve or deny variance of use for the terms of the zoning ordinance. The board may impose reasonable conditions. So you can say, we're gonna grant this variance, but tied to this variance, you need to have such and such amount of, setback or this sort of material, things like that. You can make that, but you need to make it in the finding itself. But a variance may be approved under this section only upon a finding in writing that all of these things are met. First, that this variance will not be injurious to the public health, safety, morals, and general welfare of the community. Two, the use and value of the area adjacent to the property included in the variance will not be affected in a substantially adverse manner. The need for the variance arises from some condition peculiar to the property involved. The strict application of the terms of the zoning ordinance will cause an unnecessary hardship if applied to the property. And the approval does not interfere with the comprehensive. So number 5 is think about the comprehensive plan. Where is it going? Is it moving along with what it is achieving? Number 4 is one that term unnecessary hardship we're going to come back to. So I'm not going to get into it in these next few slides, but
Could you talk a little bit more about 3?
The need for a variance arises out of some condition peculiar to the property involved. So when you look at that, there is something about this property which does not allow me to meet the setbacks, let's say. And so I'm asking a variance of this front setback of X amount of feet because it just won't fit in this property and it's different than the way other properties are lined out. Things of that nature, or it is a topographical thing. I've got this huge swale in the back of my property, which cuts it way down, so I can't fit anything in for this back setback, or, if you have a side setback, things of that nature, or I can't put a fence back there because of this, so I'm asking that I be allowed to put it on the outside of the swale.
But they could also not put a fence in.
They could also, that's why they come ask, that's the thing, they come ask for the variance.
The findings are really set up to make it hard to find the answer to be yes. They're really set up with a very high bar that it's difficult if you take them in their strictest applications. To have those positive findings, so, you're really trying to make sure that what they're wanting to do, there's good reasons that support varying from that.
I'm thinking back to one that Christine and I know about, where we approved a fence that was taller than it was supposed to be because, you know, they were gonna do all this fancy stuff and make it fancy and all that. Well, they never did. They
Yeah.
put up the too tall fence.
Is that was that brought as a use or design?
It was
Or
development
Development
standard.
standard, so, development, so we'll get into that one, that's under 918.5. So, the use is really gonna be how to use this type of thing when you look at certain things. But when we get into it, it begs the question, what's a variance? So, variance is described as a dispensation granted to permit property owner to use his property in a manner forbidden by the zoning ordinance. It's not a function, though, of a variance to provide for limited non-conforming uses simply as a matter of convenience. Nor may a variance be used for the purposes of rezoning. So I want to talk about those two in conjunction. When you see that first one, where it's described as a dispensation granted to a permitted owner. I own property. I want a variance of use to use this property for a commercial business. So I do zone residential. I would like to put in a bakery shop in my garage and sell that to people. So I come and ask you for a variance. We go through those 5 points that you have to go through. If it meets with the comprehensive plan, if it's not gonna be injurious to the public, go back to, let's look at it. The use and value is not gonna be impacted. The strict application of the zoning ordinance will make it unnecessary hardship. And then the variance arises from some condition peculiar. So if I'm thinking about a situation like that, what I would say is, under this variance, I am right next to the commercial and industrial areas. I cannot use this as a residential house. It just doesn't work. With the location it is, it's surrounded by everything, but I live there. Right, so, and this is my family home, and so I'm going to stay here, but I want to put this commercial business right here. Those are the kinds of things that you can think of. It is not a reason. So the real difference here is, I can put my bakery shop in there, so it's a commercial thing. But that doesn't mean at that point that I can then go put a fast food restaurant or something else. I have a variance for that specific use and that specific use only, and when I am done with it, it's gone. That is a variance. Zoning change is a permanent change, which then opens that property to every single use that is listed in your UDO.
But the variance stays with the property if they sold it and the next person wanted to have a bakery.
For this, if it's the same use that's been allowed, there cannot be any change from whatever that variance is granted. Okay.
We really use variances, we try to use them sparingly. If the comprehensive plan calls for commercial, they wanna do a commercial use. We want them to rezone. The times you guys have seen this is, on 40, some of the existing homes that are zoned commercial, they go to refinance. And, because they're considered legal non-conforming and that they can't rebuild in order to get that refinance or whatever, they need something. And so those are the times we tend to use the use variance. Cause long-term of the comp plan commercial does make sense. But this homeowner that's there, you want to also consider whether or not, rebuilding that home there makes sense. So those are the types of instances, the folks that have the alpacas and the llamas. They were given instead of rezoning to agriculture, again, it makes sense to be commercial. There were limitations put on their use for the agricultural purposes to limit what they the animals, the numbers and different things like that, so. You know, so those are a couple examples of how we've used use variances here. But we try not to use it, you know, if it's a commercial district and somebody wants to do something commercial, we try not to use it when a rezone makes more sense.
And that's really the second case here, right? What this second case that I have out for you, the Shelby County case, is exactly what Christine was talking about earlier. A variance isn't there to simply give a non-conforming use, oh, it's easy to give you this, let's just get it done, and it's not there to get around rezone. You must consider the information, if you want to be limited in how you give, because if you just give variances out all the time, you're taking the teeth away from your UDO. And the UDO falls under the purview of the Plan Commission and the Town Council. That's the view we're going by. So the BZA, we can't create an end around to the legislative process through the BZA. That's why you want to be very specific and thoughtful, and why you need a findings of fact that support each of those 5 categories, right? So the authority here. Whether a variance to zoning ordinances should be granted rests solely within your authority there. The only time, and the only person that can question it or overrule it is the courts. So you have the absolute authority to make the rulings on variances, on special exemptions, things of that stuff. So it's a lot of power that does come with it. That's why we have to be very stringent in how you apply that to those findings. So the evidence, this is a very important point when you could. It is not necessary that there be evidence to substantiate decisions of the zoning board denying a variance. So we already have the statute which says you need a finding of fact that supports all of those 5 points, and approval has to be in writing. This is a situation saying where you don't have to have that same thing if you don't want to, if you're denying a variance. Because the burden is upon the petitioner. They have to meet all of those 5 points in order for you to grant a variance. And so if there's any evidence out there, or if they don't meet that burden to grant it, then you don't give them the variance. So this was a challenge to Marion County saying, hey, you denied it, but you didn't go through and give me all of the findings and the evidence showing why I did improve. You don't have to go to the negative of it. You just say, you didn't meet it, it's denied, right? Petitioners for zoning variances are the ones that must establish the existence of all statutory prerequisites under that code, right? Failure to prove any one of them is sufficient to deny the request. This goes along with what I was just talking about, where you don't have to have a written document that says you failed under number 2, or you failed under number 3, and this is the reason why. It is simply a finding. We don't think you proved it. And you're done. Yes.
Regarding property values, I mean, sometimes that's subjective, and if you want to use that as a reason to deny, I mean, how do we determine, or how do we handle that, I guess?
I got some cases in here that kind of talk about property value, so we can like to touch it at that time. But it's a good question, because it's up to you as to what you determine the weight that you put on any piece of evidence. So property values, whenever somebody weighs evidence, so it's a trier of fact in the jury, you have to sit there and you have to say, okay, what do I believe more? A realtor who says, I don't believe that this is going to have a material effect on the market, or a resident who says, you're going to lower it. What carries the most? And at the end of the day, it's up to you as a trier of fact. But I think most people would go along the lines with the professional. All of them say this is going to be detrimental to then obviously that,
We've had them in here yelling at us, you know, it's all emotional.
it is emotional. And you have to kind of cut through and see what are you gonna put your weight on and what are you not.
Okay.
So now I wanna jump to 918.5 real quick. Development standards. Very similar here that the Board of Zoning Appeals approves or denies the variances, the development standards. This is height, wall, area, things of that nature of the zoning ordinance. Board may impose reasonable conditions again, and a variance may be approved under this section only upon a written determination that. So this part is the exact same as 918. Okay, except for it talks about the development standards such as height, wall, or area. This time it says the approval will not be injurious to public health, safety, morals, and the general welfare. Two, the use and value of the area adjacent to the property included in the variance will not be affected in substantially adverse manner. And the strict application of the terms of the zoning ordinance results in a practical difficulty in the use of the property. The locals, though, can make a more strict standard than practical difficulty in your local ordinances, so you have to look at that. This sounds very familiar to 918.5, but we know that 918.5 had 5 things in there, right? So we're gonna get into those differences, but here, the authority. Oftentimes what you have when we talk about design variance is, sometimes you're talking about neighborhoods. Sometimes those neighborhoods or that area has a restricted covenant that's tied to it, saying, in this area, you have to have, any fence has to be 8 feet tall. But our zoning ordinance says 6 feet is the maximum height, right? Restrictive covenants are not proper considerations for the issuance of a zoning or setback variance. As the applicable requirements are those set forth in the enabling legislation. So town passes legislation that says setback has to be here, or height of the fence has to be X. A restrictive covenant in the neighborhood cannot override this, what the town's done, and it's not appropriate evidence for you to consider when considering development variances.
Can't override it in a lesser capacity, so like. Like a taller fence would be allowed in an HOA versus the town says a smaller fence.
So, yeah, so the town, they can put the smaller fence, they can follow the zoning. So now we get into more of a private argument between the neighborhood association of whoever created those restrictive covenants and the homeowner then, but if the restrictive covenant says you have to have a fence at least 8 feet tall, and our ordinance says you cannot have a fence greater than 4 feet. The fact of that restrictive covenant being there is not evidence as to those 3 factors that we have. Is what I'm saying. There are other factors that so they can come in and they can talk about, well, one, it's not gonna be detrimental to the neighbors. It's actually gonna be beneficial because we're slobs and that's gonna hide it, whatever. They're gonna make their arguments on those 3 statutory factors. You just can't consider a restrictive covenant to justify one.
The town doesn't enforce covenants and restrictions. Those are private property matters between the HOA and the homeowners within the neighborhood. So anytime covenants come into play, it gets tricky.
Yeah.
Because we oftentimes, well, our covenants, I'm like, I'm sorry, I can hold on to what the zoning ordinance says, not what the covenants. That's the HOA. Would have to take that.
We may cover this later, but if a person has already done something that's in violation of our ordinance. Then what's the process there, and is there any kind of, if it's been there for, 2 years, we can't do anything, or. What process?
It's because there's no real. So it's like kind of like when you talk about adverse possession. So adverse possession is if I live next door to you and I use your property, like we share a property, but I always mow it. You don't mow it, I'm open and notoriously using your property. In 20 years, it becomes my property. Okay. But you don't get that against a town, because a town or municipality is so large, there's no way that it can know everything that's going on with it. So if somebody has violated our zoning ordinance, it's really, when do we get notice of it? And when do we bring it forward? So once we see it, and then we start the process, I don't care how long it's been. And then we do go to that second prong about the hardship, where it can't be self-created, right? You cannot be a bad actor and create the hardship that you're saying you want to get over. So,
I mean, it's like, we've talked, there's on Harvest land area, there's a house that has a fence that's in violation. But it's like on a dead end street, so it doesn't really make a difference, you know, when I'm talking about the white fence, it precedes the house, which, you know, it should, those kind of things. So it's kind of up to the Christine and the town, whether they want to do anything about it. This is what it comes down to at that point. But even though it's been there for 5 years, if for some reason that street would maybe all of a sudden go through and there'd be a lot more traffic, maybe then
yeah.
we could go back and say, hey, you gotta either file for variance or remove the fence.
It also doesn't set precedent for anyone else, and if that fence were destroyed, they wouldn't be able to rebuild.
I'm thinking of the sign on the side of the building, but that's another thing.
You got 5 people to convince before me. They've
That's before your time too.
they've given me my direction.
So then, BZA has authority under the governing statute on the variance for development standards to approve or deny a variance request, seeking the reduction of required lot frontage and area from subdivided parcels. In a proceeding where the applicant sought to rezone certain parcels of land in the agricultural to residential. Ground point case where, when you have two things that are kind of going at the same time. I've got a request for rezone, but I'm also asking for a variance. It's not like one trumps the other, right? You can still take action on that variance request when I'm talking about setbacks from here or there, regardless of what's going on on the other side. We get into the evidence again. When determining whether you're in compliance with the zoning ordinance will result in practical difficulty. So this is exactly what you were talking about a second ago. These are the things that you can consider. Whether significant economic injury will result from an ordinance is enforced, whether the injury is self-created, and whether there are feasible alternatives. This is what it means when we're talking about that practical difficulties.
Is this the same as hardships or different?
With that. BZA granted variance to build a second residence on the property was neither arbitrary, capricious, nor an abuse of discretion. The BZA considered drawings, proposed evidence, and granted variance for construction of second residence on other properties in the neighborhood. They considered all of these things, and so in this case, the neighbors came screaming and yelling, this is gonna lower our property values, this is gonna do all of this stuff. BZA granted the variance, and it talks about everything that they considered. They looked at the drawings, the proposed residence, and it says, while it's not binding and precedent centered, they granted variances for construction of the second things in the past, and they'd seen how it impacted things. This is the same case, this is a case we go to all along, a lot. That the allegations from the neighbors alone that showed concern over the negative impact of their property values and the applicants for the variance. So you're saying it's going to impact property values. I don't say a thing about it. It's not sufficient to refute such concern. Like, I didn't come back and refute it. Does not mean that there's not information or that you can't consider. That I met that criteria, that it won't have a negative impact on the property values. When you look at it as that 15-foot setback from the road would not have a substantially adverse effect on the use of the value in the adjacent properties. A statutory element for granting variance, such allegations ask the reviewing court to reweigh the evidence, which reviewing court would not do. What this means is, I can come and say it's a negative impact on my property, but if what everything is being shown to you and you decide, now, I don't think it's going to have an adverse impact. It's not up for review in court to say, well, there's not enough evidence. When we balance this out, there's not enough evidence for you to have made that. If there is any evidence that you could have relied upon to reach that determination, you're going to be at that. Right? That's what you look for when granted. You look like you had a question.
Well, I'm thinking of one where they had like a trailer on the property. It was the old Glen Oaks, the north end, where they had a storage trailer on there. I think we ended up approving that. Because I think part of it's because nobody came and complained, as I recall.
Remember this?
That's been quite a while ago. I slept a lot since then. But, yeah, there was a house and that thing had been there a long time. As I recall, and nobody, at the meeting, nobody's, complained about it or anything. It did look kind of weird, but.
And the way to think about it always is, if we're talking about a development standard, we look at those three prongs, and if it's a use variance, it's the 5 prongs, right? You want to tie it to those things. And
And that's why we give you guys the whole findings worksheets. So in your motion, you address those findings, even if all you say is the reasons discussed in the meeting tonight. It gives us something if we end up in court that we can show, hey, we did talk about these things. And took them into consideration, and it just helps demonstrate that and gives us another piece of evidence.
And so 3 of them are pretty similar when you talk about a use variance and a development variance, right? Number 1, approval will not be injurious to the public health, safety, morals, and general welfare. Look at the development variance, not injurious to the public health, safety, morals, and general welfare. Under use variance for 2, the area adjacent is not going to be affected in a substantially adverse manner. Look at number 2 for the development variance. It's kind of the same thing. Now we jump down to number 4 under the use. 3 we talked about earlier, which is different. But when we look at 4, the strict application of the terms of the zoning ordinance will constitute an unnecessary hardship. If applied, it's similar under the development, but it's different. Under the development, it says the strict application of the terms of the zoning ordinance will result in practical difficulties of the property. And then it talks about, however, we can make a higher standard if the community wants to. So what does that mean? What is the difference between practical difficulties under design variance and unnecessary hardship?
How about if they want to do something, I'll use this as an example, because I think maybe we've talked about this before. Somebody wants to put indoor swimming pool in. But because of the topography of the land, they have to be too close to the property. Well, the fact is, they don't have to put a swimming pool. Maybe they want to, but if they don't have to, so I mean, to use the house, you don't have to have a swimming pool. So how do you handle that kind of?
Well, you have to look again to all of the standards and see if it fits in. So with that, you are talking about a design or development standard variance setbacks, right? So it's the 3 things. Is it going to have an impact? Is it injurious to the public health, safety, and welfare? Probably not, right? Is it going to impact the neighboring value negatively? Most likely not. So those 2 are probably set. And so now you're at the practical difficulties question. And that practical difficulties question, this case tells us when you're thinking about it, these are the things that you can consider, but you're not limited to this. But in determining whether compliance with zoning ordinance will result in a practical difficulty. So this is for the design variance. You consider whether the significant economic injury will result from it if the ordinance is enforced. I don't know that a significant economic injury is going to be there if you can't put a pool, right? There may be an economic benefit because you're not spending all of that. Whether the injury is created, so what we're talking about where I know it or I do something So I've created it, and then I said, it's gonna be such a practical difficulty for me to change this thing that I have already done. And then whether there are feasible alternatives for the factors. It is completely subjective to you. If your position is, I don't see how this is a practical difficulty, because it does not, I don't know the economic injury, I don't know, any of the other problems here. Like, you bought this property, you knew this property was set out this way, so you should have thought of it before if you were gonna put it in. And are there feasible? Yeah, put in a smaller pool.
Retaining wall.
Well, it's kind of like the fancy fence house. I mean, they didn't have to put a fancy fence, they could have put a fence that was within the criteria that we have.
Yeah.
But they wanted a fancy fence. And so at that time, we had a couple of people on the BZA that were, well, let's be good neighbors, and so it got approved.
It, one thing that I would say is, when you look at these variance requests and things of that nature, it goes back to what Christine was saying, is they should not be given out like candy. They are, you have to meet the statutory finding in order for it to qualify. And so if they're there and they make an argument to you, and you're like, yeah, this makes sense to me, then yeah, those are the situations to go through, but you don't want to just give them out to everybody who comes in. Because then it renders your UDO meaningless, and can't do that. So unnecessary hardship comes into play for the use variance. It is a little bit different. So in determining in the determination of unnecessary hardship as grounds for granting, it's governed by all relevant factors when taken together that indicate the property cannot reasonably be put to a conforming use because of limitations imposed on it by the ordinance. Okay, this is a much broader consideration. You can think of and take into consideration a lot more stuff. And when I look at everything together, does it mean that you cannot use this property essentially as the way that it's zoned? So it's a residential property, and you're saying, I can't use it as residential. It's got all of this stuff around here. Look at this. And when you consider everything, you say, yeah, that makes sense. But we're not going to go through the process of rezone. It falls under this situation, just kind of like what Christine was saying about along here on 40. So those are the big differences between the practical and unnecessary hardship. When we look at the practical difficulty standards again, so back to the 918.5 for the development. This is a big case. It says a lot in here. But essentially, there is no evidence that the strict application of the zoning for which the builders sought development standard review would result in an economic injury to the builder as required to show practical difficulties. The reason why I put this case out here, so if you go through and you read all of this, these lots were kind of small lots. In order for him to meet with the setbacks and things on these lots, he was gonna have to build a smaller house. And he's saying, that's my economic difficulty. Courts said, that's not enough. Any evidence of the builder's financial hardship if it were to build a smaller home, there's nothing in it, like, so just the builder saying, I've got to build a smaller house on this lot based off your stuff, that is not enough to prove the difficulty standard. It's cool. That builder is going to have to come in to say, hey, these lots, as you have them drawn up with the way that you have your ordinance set up with setbacks, requires that I'm going to have to build a house in this size. This size of a house in this community, they're gonna have to give you some study that shows it diminishes the value of that development in a substantially harmful manner.
But in most cases, it's already been approved, like platting's been approved, the plan was provided, the cost estimate was there, but we actually just ran into that not too long ago with DR Horton when they had asked for an increased setback to build the builder, or build the next home size. And it was approved,
Right.
which is interesting.
But it's somewhat discretionary in your guys' end.
Mhm.
And they weren't necessarily claiming, the practical difficulty wasn't necessarily, they weren't claiming financial on that one. Trying to remember what. It was the alley or something I think they used, but
Yeah.
it was weak, but
I don't think they were claiming anything, they flat out said that we could build a bigger home here, so.
We can build a bigger home.
wait, that one went to plan commission because it was a PUD amendment.
Yeah.
Yeah.
it's a
So
PUD.
it's what their standard is different, so
They changed it there because
They
of that
changed
versus
the
going to
zoning.
the.
Yeah, they asked for a PUD amendment,
yeah.
so they could have a, what was it, less setback or something. I can't remember,
So that
because
they
they're-
could do that, because they wouldn't have been able to meet the standard. So they went through the PUD amendment, which is changing all the zoning. And so, completely different set of criteria and things like that.
So get a PUD.
Well, it depends.
It depends on what you wanna do.
And when,
And it's not necessarily easy to get a PUD amendment either. In their case, what they were doing, it actually made sense, but.
because with the PUD amendment, in any PUD, it says a rezoning process, right? It is a map change. And so DR Horton would have had to put the petition, plan commission would have had the public hearing, which means everybody sitting here screaming and yelling.
Which we did.
And then you guys make a recommendation at the plan commission that gets passed on to the council
Yep.
to have their final action to change the
Yeah.
map. It's a different process, but it makes sense when you're talking about an entire development type situation. When you look at these variances, we really should only be talking about a single property owner comes in. I own this property and I want to do this. If I'm talking about 50 parcels, go get a PUD set up or go to zoning. Don't come to me, because I can tell you one thing. You're not gonna prove to me that it is unique to that parcel if you're making it for all 50 parcels.
Okay.
Right?
And that's really. It gets difficult, we try to encourage PUDs. Because the development standards aren't necessarily set out. For today's kind of housing developments. But we also then, there are other things that have to meet, and we're like, you can't bring us a regular neighborhood either. There's gotta be something special to actually warrant the PUD. So there's more negotiation and there's some things that go on there, so.
What is a PUD?
It's a,
Planned unit development.
Plan unit development.
So essentially, it is kind of these, the way I like to describe it is a zoning classification, like R1, R2, commercial, industrial. Except for, it is a zoning classification that I say, this part here is gonna be R1, this part here is gonna be R2, over here is gonna be mixed use development and commercial. So you have a bunch of different things that are combined into this development. So you know, it's a combination of all of these other zoning classifications into one big property. But it's still that governed, that larger swath of property that they cut.
That's what was done for most of these new ones we were approved.
On 740, that's a mixed use.
Everything that we've approved most recently was all in PUDs.
Because when you talk about those, it's hard to just zone them under a regular zoning, because you're gonna have single family residential, and then you're gonna have some multifamily residential, and then there's some commercial that's gonna support it, and then there's some heavy commercial or whatever, the professional district, which is gonna be part of it. So you have all of these different things. The only way to encompass all of that is to put it into a planned unit development, which we simplify.
And they have their own standards that are
Mhm.
that are different from towns, but if they don't address a particular item, the town standards are by default cover it, so.
theoretically, they should be, equal to or better than kind of what the expectation is for your existing zone.
Okay.
Yeah, there are certain communities out there. And it drives me nuts, and I work with this community and I just can't get them to change it. But do all of their zoning as a PUD, which is mind boggling to me, because they will have one parcel that's a commercial parcel, and they'll say, we're gonna do this as a PUD. I'm like. Just rezone it normally as commercial,
And just so that, like, to me, that says, hey, we need to go look at our commercial zoning standards, they probably need updated. I mean, that's why we're really pushing PUDs for a lot of things, because otherwise they would need a slew of variances to make things work. Now, once we do our comp plan, then we'll come in and do new ordinances. That probably changes some.
So once granted a PUD, then it goes to plan commission, then town council.
Plan commission makes a recommendation and then it goes to council.
Okay.
it's just like a zoning change.
That's a
So it's
reason.
just like me changing my property from R1 to commercial. That's what a PUD is gonna be. Ag for this big piece of property and divide it into all these different uses. So, really, and that is what I have. I was guessing as to how long we were gonna go. I got a little extra time on this one, so I got close on others. But really. The takeaway from this is when you talk about a special exception, which you have. Is if they meet the criteria, you have to give it to them. And when it comes to the variances, make sure to follow the statutory considerations. If you're going to give somebody a variance. And make sure that you have information that answers each of those criteria. The 3 for the development, the 5 for the use. Because only upon getting evidence on those can you then grant the variance.
And read very carefully what Christine is telling us in her reports. And because we've had some things backfire when we've gone against her recommendations in the past. So,
Should stay.
and well, like she said, it's, be very, these aren't, we're not handing these out as, Halloween candies.
And I will always take a strict stance on BZA cases. That practical difficulty and hardship. Even though sometimes it's like, oh, common sense says, yeah, this is like no big deal. I'm still gonna take that stance, one, because I think that my job as a planner is to do that for you. But also I don't wanna set up a situation where then somebody's like, well, you're always gonna get the, well, the last one, you said it was okay, and ours is exactly the same. I'm really gonna push them to provide that evidence to you, to make their point.
And
And
that's,
they should have to work for it.
just to kind of, that stays with the property, right? Because like there's that building that sits back behind the car repair.
Yeah.
There was that building that
That's-
we approved the ramp,
Yeah, which.
but it never got
which
done
one?
because they
So-
never rented it, but I know.
A use variance sticks with the property for that particular use, right? If there's a change in use, it's gone.
Yeah, they wanted to put like a loading dock, where you put a ramp down so they could have the building, the dock be the same height, but it never went through. I mean,
Yeah, they never did it and it's sold.
then it's sold again.
Um,
Still empty.
we did the contractor's yard down on 40. And that since has moved on, it's no longer being used that way. They're using it in a different way.
The shambles. property.
The
We have
one,
shambles too.
but no, this is the one just next to it where we have the cars. So the variance and the conditions related to the contractor's yard were only for that use.
Right,
So even if the use changes, the conditions we put on the contractor's yard don't necessarily apply. So that's probably a good example of kind of how that would work.
And there are a million other cases under the 918 series, okay? It would have taken us over a week to go through all the cases. I was just picking out a few that I thought would be relevant to what you're doing here. But if there are other situations that come up, and you have questions about it, don't hesitate to ask, say, hey, what is this? And then I'm telling you right now, I don't know all the answers about it, but we'll go look at those cases to see if something's come up that can be applied to.
I'm also assuming that it would be kind of like other things, that if somebody wanted to do something that lived right next door to me. And I probably should recuse myself from that because,
You were supposed to be an impartial people.
so if the next door neighbor wanted to do something. And I didn't agree with it, I should probably,
If you can't be impartial, then you should recuse. If you have any questions about that, reach out to me or Jewel and Christine. Prior to the meeting, so those can be talked through to help you determine whether or not you need to.
And don't go investigate.
Yeah.
You are an impartial body. You are supposed to make your determination on the evidence given to you at that hearing, right? And so it's similar to like police discipline and things like that, when the merit commission hears it. If you've gone and done your own investigation, then perhaps you are considering something in your decision that was not presented in evidence in the hearing. Well, you shouldn't be considering that, right? You should be considering the evidence as provided at the hearing for the variance or for the special exception.
You guys are a judge, and you're the judge and jury.
So the investigation really is done
Yeah.
on this part, and it's going to be part of your packet. Planning commission is gonna say, here's the zoning here, we believe that it doesn't meet this, and this is the reason, blah. And then you're gonna have public talk.
Right. And it's technically the petitioner's responsibility to make their case for their variances. When you get a homeowner coming in for variances, I'll be honest, they don't always know what to do. We do our best to try to guide them. But when you have attorneys and others coming in, like, the burden is on them to prove it, not on staff. So sometimes you guys might ask me a question, I'll say, well, you should ask the petitioner that question, because it's the
I have a
burden.
problem
is
with
on-
what you just said though, because if they're talking about, say, topography of the land. I mean, until I can see it personally, I would have trouble judging.
Well, then they did not do a good enough job convincing you or providing me the information that you need. I mean, that's the way that I would take it, because if it's the topography of the land, they've got concerns, the way I would present the case if I'm asking for a variance. If I'm saying it slopes drastically, I would be out there both with the video camera to say, here's the topography as you can see it. Having a level there, and then also, one of the things that I know planning departments love to do when they're trying to deny certain things on slope ratings is. There's a formula that you take a string and tie it here, and then by this point over here, depending upon how tall the stick is, you can demonstrate all of that stuff. That's what they should be going to prove it to you. If they don't have that, then they're hurt.
They can print, I mean, GIS has contours, I mean, there's lots of different things that can be used to show that. Pictures.
That's what I did to get out of a speeding ticket one time. I went back to the road and took video for miles. There's no speed limit sign posted. I was just guessing. This was back before GPS and all that, and I showed it to the judge and he's like, okay, I understand. He threw it out. But I had to go to a lot of
As
trouble.
he clocked your heat on there.
Well, I wasn't doing that much. It was, 55 and a 40 or something like that. But it was out in the country somewhere. There was just no speed limit signs. I'm looking.
And because you guys are judge and jury, you shouldn't be talking to each other and you cannot talk to anybody else. So if your neighbors contact you about a case or the petitioner or anybody, you should be directing them back to me and then also let me know who has made contact with you. We have basic information on our website for who's on the BZA because we're required to have that posted on our website. But we also have on there that you guys are not allowed to be contacted because you're quasi judicial. That will not stop people.
Quasi judicial.
Yeah.
And I didn't get into those steps. I focused on the 90. Remember, there's a whole 900 series. So before we get to 918, that means we had 900 and 92, 93, 5, 6 to 17, right? And so I didn't touch any of those. Those are a lot of the formation. What are you? How do you get appointed? What authority do you have? The 918 is the
Right.
actual stuff that you do.
Yeah,
And we can touch and go through that training later. I just thought this was.
Yeah.
And if you see them puckering up a little bit during this, just stop talking.
if we start talking to each other,
Eyes rolling or whatever.
that would be me. Don't use eye rolls as a judge. Yeah, but make sure you read the staff report, read what's in there, and then if you have questions on the way something is stated or asked, or those are good questions to be asking staff during the hearing.
Do you think we have anything coming up for next month?
No. I don't have anything on my radar for BCA.
What does that mean?
Easy.
Slow or just?
It
The ordinances.
it comes and goes.
Well, we had one this year and one
Yeah.
last year, so. Thank you very much.
Yeah, it tends to be, the issue we've had a lot here was fences and easements, and we amended the ordinance to allow an encouragement agreement, and that solved a lot of our issues. And so if they sign that agreement and it meets certain standards, then we can do that, and that saved you guys from things. So usually if you're seeing a lot of variances, it means we need to go back and look at our codes. And when commercial develops, usually you see sign and parking variances. So
Well,
some of
I see.
it's just kind of the nature of what's being
This
developed.
economy, you see a lot of people working out of their homes now or starting businesses out of their homes. Now, they technically should be applying, right, for
In some cases, it depends on the way,
Depends upon the
what they're doing and yeah, how.
If I'm inviting everybody to, like, I'm at home and I'm making something and I'm selling it out of my home and inviting the public to come into my home to purchase it, that is different than me sitting here and I'm making this thing and then I'm shipping it out on eBay
Oh,
or
right.
Amazon. Right? But if they're increasing the traffic to that, then that's
I
the
think
time.
I told you about one time, because we had somebody in our neighborhood that was doing music lessons. It's like, well, okay, they have, the occasional person come to their house to get piano lessons or something, but is that really?
And there's some standards associated with it in the code. And I think when we update our ordinances, some of those things are the things that we'll have to look at because the world has changed since
Sure.
those standards were written. The home occupations, and there's a few other things that just, temporary uses, food trucks, Airbnbs.
It's probably
There's a bunch of.
25% of people in our neighborhood work from home.
Yeah, a lot of people do.
Mhm. But if you're just working from home and have an office out of your home, that's fine. It's when, oh, I want to have an auto repair business out in my garage.
Yeah,
That's
You
probably,
mean like the one on Buck Creek?
See,
I know too much, right?
Ted, this is live streaming.
I'm sorry.
so,
All right, if there's nothing else, I guess I'll entertain a motion to adjourn.
I moved to adjourn.
Second,
I'll second it.
all in favor? Aye. Opposed? Shut the live stream off. All right.
So that we can all go home.
Yes,
Yeah.
I haven't had dinner yet.
I thought we did.